The topic is going to be guardianship, and the Honorable Robert Rusu, Judge Robert Rusu, will be presenting. Judge Rusu has always been very helpful to us in providing the presentation on guardianship, and he's always been a very big supporter and a big help and advocate for individuals with developmental disabilities. He has been the judge in the probate court for several years, and we are honored to have him here this evening. And again, I want to present the Honorable Judge Robert Rusu, who will be talking about guardianship.
Hello, everyone. Thank you, George. I appreciate that introduction. This is a little different for all of us. Most everybody is at the comfort of their home, which is always nice. I wish I was there, so I'm a little jealous of you all. I do have a few people here in the audience, so I'm going to be looking around a little bit. I am going to start, and I'm going to share my screen with you. So I'm going to try that, make sure I don't mess it up. Share. Okay, so there you are. You got another picture of me, like you need to see me. But here's basically the question we're going to talk about tonight. We're going to talk about that if you have someone in your family that has a developmental disability, where do you go? What are the types of things? How can you make decisions for them? And so there's really two alternatives that you have. The first alternative are power of attorneys. We've all heard of power of attorneys. And we're going to talk a little bit about what types of power of attorneys there are, how you get a power of attorney, who can qualify to have a power of attorney. And then we'll also talk about legal guardianship. So that's the second thing that we're going to talk about. So we're going to start off and we're going to talk about power of attorneys, because that's the most prevalent that you'll hear people talk about. Do you have a power of attorney for your loved one? There's two types of power of attorneys that we're going to focus on for our discussion tonight. The first one is a financial power of attorney, and then the second one is a medical power of attorney. So first off, what is a power of attorney? What does it do? A power of attorney is nothing more than a legal document that allows one person who suffers from an injury or a disability to nominate another person to act for them. So it's just saying, I want you to do something for me. That's all a power of attorney is in its basic form. Now, like I said, there's two types of power of attorneys. The first one is financial. That's the type of power of attorney where I can nominate somebody to handle my banking affairs. So I can nominate my wife. And I say, I want my wife to be able to handle all my banking affairs. I can be more specific. I can say she can only handle my banking affairs at one specific bank. Or I could say she can handle all my banking affairs at any financial institution, whether that's a bank, an investment account, an investment house, an IRA, an annuity company, a life insurance company. So it just allows her to handle anything financially on my behalf. We typically think of a financial power of attorney to pay your bills. If somebody's in the hospital or a nursing home, you need somebody to pay your bills. Second, you may need to have file your tax returns, especially with this last pandemic that we just went through. You could file for a stimulus payment. You could file for some unemployment benefits for a loved one that may have lost their job because of the pandemic. And if the person can't do that themselves, then you can do that under a power of attorney. You can also do such things such as assets, transfer assets, using a power of attorney. It's a way to avoid getting a guardianship if that's the only alternative you have. And we're going to talk about that here in a little bit. You may. Yes. The question is, we have an audience member here that just asked me a question. Are power of attorneys and guardianships two different things? And the answer is yes. They are two distinct, different things that we're going to talk about tonight. So we're going to first talk about the power of attorneys, and then we'll go into the guardianship. Okay? Yep. So here's our second type of power of attorney. Our second type of power of attorney is the medical power of attorney. We already talked about the financial, what that does. The second type is a medical. That's a legal document that allows somebody to make your medical decisions. If I go to the hospital, I can't make my own medical decisions. If I can't tell the doctor what I want done to me or what I don't want done to me, I can nominate somebody to make my medical decisions. That's a medical power of attorney or a healthcare power of attorney, if you've ever heard that term. I can be very general and say I allow somebody to make all my medical decisions. You can also be very specific in that document, and you can tell them that you want them to be able to make end-of-life decisions, such as terminating respirators or ventilators if you're on one of those. You can authorize them to sign a do not resuscitate order on your behalf. So you can be as specific or as general as you want in those power of attorneys. These documents you can find relatively easy at your local library. You can find it on my court's website at the Mahoning County Probate Court. These are free documents that the Ohio Bar Association and the Ohio Medical Association have put out. So you can download these documents right off the website, print them out, fill them out, and then you either have to get them signed by two witnesses that are not related to you or a notary public. So it could be either or, two witnesses that are not related to you or a notary public. So or they try to make it easier for you. So if you don't have two people you can find, you can go to the bank and get a notary to do it. Can't find a notary, you can just get your two friends to do it. Another question, okay, that's okay. To become his power of attorney. So the question is from the audience, is that they have a son that has a disability, and she said he would have to nominate us under the power of attorneys to act for him, and that's correct. You need somebody to be able to say, yes, I want you to be my power of attorney before you can start acting for them under the power of attorney. We're going to talk about that if you want to hold that question just a little bit longer, because we're almost to that point. We're going to get into that, and I'll tell you how that happens. Okay. So the power of attorney is only valid if the individual is what we call competent, mentally competent. They have to understand what they're signing. They have to understand who they're nominating to be their agent under the power of attorney. And then they also have to understand the consequences of that decision. So typically you would talk with your teachers, your case managers, your doctor, and you would ask the doctor, do you believe my, in this case, child has the capacity to enter in and make a valid power of attorney? We have different individuals on different scales of autism or on the disability scale. There are some individuals that are very high functioning that do have what we call competency to execute those documents. And then we have some individuals that are severely disabled that don't meet that criteria and won't be able to execute those power of attorneys. So if you have that situation, then your only alternative would be to do the guardianship. And that's what we'll talk about here today. So if you have a high functioning disabled child in this case, then they would be able to execute a power of attorney, get them to sign the document. Usually you could go to an attorney. The attorney would be able to help determine whether they have competency or not. A letter from the doctor also helps the attorney when you go to visit them, and they could sign that power of attorney, nominating you to make their medical decisions, as well as nominating you to make their financial decisions under the financial power of attorney. If you have an individual that is severely disabled, or the doctor and the attorney believe they don't have the competency, then your only alternative is the guardianship. Okay? Does that explain that? Okay. Well, he doesn't have to make the right decision. You're not following the question. Is she was saying her son was is being told that he's high functioning on the autism scale. The question is, does he have legal competency to sign a power of attorney? He doesn't have to make other decisions. The only decision that we have to determine is, does he understand what he's signing, the consequences of what he's signing, and then who he's nominating to be his agent. If you don't believe, and the doctors don't believe he has that capacity to understand that.
But if I lose, I'll call you back.
Yes, the doctors would give an opinion to that effect. Then the lawyer who is drafting the document would ultimately be the decision maker. Now, there are attorneys that will sign it even though they believe maybe the person doesn't have the competency. You may run into a problem down the road if you go to use that document. You may have a institution or somebody say, we don't believe your son has the capacity when he signed that document in 2020 to make a valid decision. So we're not going to follow that. You always run into that risk. But if you do have a lot of medical evidence and testimony, medical documentation, not testimony, that says that he's high functioning and he understands those decisions and that he wants you to be your decision maker, then the power of attorney is a valid option. Okay? All right. It's a lot. That's a lot. All right. So let's say you have an individual that cannot execute a power of attorney. The doctors, the lawyer, his SSAs at the DD board, his teachers, they say he or she just cannot execute those documents. Where do we go? What do we do? Well, our only option is then to seek court involvement and then seek guardianship. And that's a legal proceeding that we're going to talk about next. Here's a little outline of where we're going to go. We're going to talk about the different types of guardianships. We're going to give you a definition. We're going to tell you that there's two types of guardianship. There's a guardianship of the person and there's a guardianship of the estate. We're going to tell you how that process gets started, what happens once you get the process started, the legal proceedings, and then we're going to talk about complaints. If anybody has a complaint about the guardian, what you can do. Down here. So what is the definition of a guardianship? The definition is of a guardianship is a legal proceeding under the Ohio Revised Code where a court appoints one person, a guardian, to make decisions, medical, financial, or both, for another person called the ward, not make their own decisions due to illness, disability, or substance abuse. So if you have a loved one that is disabled and that disability prevents them from making valid, rational decisions, then the guardianship is what you would need to start at the probate court to be able to make their decisions. So how do we start a guardianship? Well, the guardianship is started by filing an application down at the Mahoning County Probate Court. We're talking Mahoning County. Now, if you live in a different county, if you live in Trumbull County or Columbiana County, or maybe even Summit or Portage County, these are standard probate forms that every probate court uses in the state of Ohio. It's standard probate form 17.0, and it's titled Application for Appointment of Guardian of Alleged Incompetent. This is a simple fill-in-the-blank form. I highly suggest that you get the assistance of a lawyer to help you fill out this form to make the process a little quicker, and it'll make it easier for you guys to go through that, because I always joke to people, I can do a lot of my own repairs to my car, but usually it takes me twice as long and twice as much money as if I would have just taken it to the quick lube or the repair shop and have them do it. So I try to get somebody that's the person. It's not a real complicated process, especially for a parent to seek guardianship of their child. There's a lot of free clinics around the area that will help you for little or no cost. So you want to inquire into that. Down at my probate court, we have a list of attorneys that will volunteer their time for you. You just have to come down and ask that one of the lawyers be appointed for you, and we'll appoint one for you, and we'll hook you guys up, and they'll help you, walk you through this process. That's something that I started when I first took the bench, and the lawyers were very quick to jump on that process. One of the first things that we require when we start that guardianship process is we require a statement of expert evaluation. So we're going to want a statement from your loved one's doctor, your disabled child's doctor, that tells us what's the problem, what are they suffering from. And that's done through this other standard probate form called the Statement of Expert Evaluation. It's another standard probate form. It's called Standard Probate Form 17.1. And this is a form that either a licensed physician or a licensed clinical psychologist has to fill out before you can even file the documents. You need that documentation before, because that tells the court that your loved one is suffering from some disability that prevents them from making decisions on their own behalf. So it gives us some probable cause to go forward. So you get this filled out. For you family members that have loved ones that are going to start transitioning out of high school, so they're turning 18 here fairly quickly, you'll want to start this maybe 1 or 2 months before they turn 18, because you can't do it before they turn 18. If they've already turned 18, don't worry, it's okay. You should start looking into it now, because at some point in time, you're going to need to make a decision, and they're going to the hospital or the doctors or somebody's going to want a legal decision maker. And if they weren't able to sign a power of attorney, you're going to have to get the guardianship. So you don't want to put it off too long. 18 in March he turned, that's okay. If he turned 18 in March, you're not that far off the, so you'd want to start the process here fairly quickly. Excuse me. We have a question.
For this expert evaluation, once it's done, does it need to be done annually, or is once sufficient for?
That's a great question, and I'll repeat it just in case everybody didn't hear. Once the statement of expert evaluation is completed, is it a one-time and done, or do you have to do it yearly? The general answer is you have to do it yearly. I will sometimes waive the requirement filing it yearly if the guardian asks me to waive it based upon the fact that their loved one, the ward, is suffering from an illness that is not going to change. Typically with a developmental disability, it's not going to change. It's a permanent disability, and I will waive that requirement. However, I don't do it all the time, because we have individuals under guardianship that have to get guardianship because of dementia, because of Alzheimer's, and I want to still see those statement of expert evaluations to see how they're progressing. If they're getting worse, if it's getting better, if it's staying still, I want to see that. So not everybody is suffering from a developmental disability. So I have a lot of people age 18 up to age 90 plus that have a lot of different disabilities. And so I don't wait them all the time. So the general answer is I require them annually. But if you ask me, and it's a permanent disability, I will entertain the motion to waive it. So you don't have to do it, you only have to do it the one time. Good question. Okay, so here's a important question. Who declares your loved one incompetent? Is it the doctor? Is it the lawyer? Is it the SSA at the DD board? Well, the answer is, the easy answer is the only person that can legally declare somebody incompetent is the judge. I'm the only one that can declare the person incompetent. So that's important, because a lot of people will say, well, the doctor says he's incompetent. Just because the doctor says he's incompetent doesn't necessarily mean that he's legally incompetent. He may be incompetent to make informed medical decisions, but he may or she may not be legally incompetent. So I'm the only one that can make that decision. I rely upon nurses, doctors, aides, family members. They all have to tell me what's going on in this life before I can declare them legally incompetent. Once I declare them legally incompetent and I appoint a guardian for them, then that person loses the ability to make their decisions. The guardian then has to make all their decisions. where they're going to live, what they're going to, where they're going to go to school, or if they're going to go to work. All their medical decisions, they have to help them. I instruct the guardian that I want the ward to be involved in all decision makings if possible. If your loved one can make a lot of their decisions, you just need to assist them. You guide them, you help them make the decision. You may be the ultimate one that has to sign the papers, but involve your ward, involve your loved one so they feel part of the process. Because you wouldn't want anybody just making all your decisions for you. So you want to include that person in those decisions. So where they go to school, where they're going to go to work, if they're going to go see a new doctor, or if they're going to move to a different home, if they live in a group home, try to get them involved in those decisions. They feel part of the process. But legally, the guardian is the only one that can make those decisions legally. That's important when you apply for public assistance benefits, through Social Security, through Medicaid. They're going to want somebody that has to be able to sign those forms, and that's what the guardian does. That doesn't mean your ward cannot go with you to those meetings and to help gather the documentation, but the guardian is the one that actually has to start that process. All right, moving along. Okay, so after you come down to the court and you file your application and your statement of expert evaluation, what happens? Well, the first thing that we do is we're going to give you a hearing date. We're going to say we're going to have a hearing that everyone has to come back to, and that's going to be usually between 14 and 30 days into the future, because we have to get notice out to people. I have to send my court investigator out to do their job. The court investigator's job does two things. First, the investigator has to provide notice to your loved one, to that prospective ward. They have to let them know that you need to be their guardian. Under the Ohio Revised Code, if you had somebody file guardianship over you, you'd want to know it's going to take place and it's going to take place. So I'm required to give you notice. So I'm going to give your guardian notice of when the hearing's going to be. That notice has to be served on the ward at least 7 days before the hearing takes place. We can't serve it to them today and have the hearing tomorrow. It has to be done well in advance, and it has to be 7 days in advance. The other thing my investigator is going to do, my investigator is going to talk to your loved one, and they're going to advise them of their rights. They have certain rights. They have a right to be present at the hearing. They have a right to be represented by a lawyer at that hearing. This is one of the only proceedings that's not criminal that you have the right to get a court-appointed lawyer. So if your loved one wants a lawyer to represent them, I will appoint a lawyer for them at no cost to them. And that lawyer will represent their best interest, and they will argue and advocate on their behalf during that guardianship hearing. The last thing the investigator is going to do once they serve notice on your loved one is they're going to evaluate your loved one. They're going to do a little investigation. They're going to talk to them. They're going to try to understand what's going on in their world, see how much they understand, see if what you put in your guardianship application is true. They want to make sure you're not lying. Believe it or not, there's people out there that want to take advantage of individuals with developmental disabilities. And so my investigator and my court, our job is to make sure that those people don't take advantage of those people. So my investigator is doing a little investigation, making sure that the surroundings where they live is appropriate, making sure that they have proper clothing on, making sure they have food available to them, making sure they've been going to the doctor, ask them where their doctor's at, when's the last time they saw the doctor. We're going to ask them a lot of different questions just to make sure that what's been alleged in the proceedings is actually true. So after the investigator serves notice, here's those rights. I started talking about the rights of the ward. I kind of got out of order. I apologize. The rights of the ward is the ward has the right to be present at the hearing. The ward has the right to contest the application for appointment of guardian. They can say, I don't want a guardian. They have the right to be represented by a court-appointed lawyer that the court will pay for. They have a right to have a family or a friend present during the hearing if they want. And they also have a right to have an independent evaluation. If they don't like the doctor who did the statement of expert evaluation that we talked about a little earlier, they can ask for an independent evaluation, and the court will pay for that. We will appoint someone to go out and evaluate your loved one at their request. So those are all rights that the ward has. So after we do that, and the ward has been properly notified, then we come to the day of the hearing. And like I said, that's usually 14 to 30 days after you file your pleadings at the probate court. All the parties come down to the probate court. The probate court's located in downtown Youngstown. The probate court is on the first floor of the courthouse. And the reason we do it in the courthouse, it's neutral territory. Nobody has an unfair advantage. It's my courtroom. So I control the proceedings. Nobody has an unfair advantage. Under a very rare circumstance, we may go elsewhere. If the individual is medically fragile, have the hearings somewhere else. I have had hearings in the hospital if the individual is too medically fragile and can't get out. We have had it in other locations because the person was just not able to travel. But you have to ask me for that, and very rarely do I grant it. It has to be a very special circumstance. I want everybody to come down to the probate court because, number one, it's two, it's neutral. Nobody has advantage one way over the other. It makes everybody feel a little bit more secure that nobody has unfair advantage. Next thing that we're going to do at the courtroom, or at the court hearing, I'm sorry, I have to answer two questions. The two questions that I have to answer is, first, is that ward or potential ward, are they incompetent? Do they have the ability to make their own decisions? Do they have the ability to make valid, rational decisions in regards to their life? If the answer is yes to that, they have the ability, then we stop the proceedings. Everybody goes home. But if you are successful and you say, my child is suffering from developmental disabilities, the doctors agree, all the witnesses that you bring tell me that this is the case, then we go to the second question and we say, who is the best suited person to be the guardian? In most cases, it's the loved one who brought the application. It's mom or dad. But it doesn't have to be. Sometimes we find mom and dad they don't have the ability to do it. Whether it's they're sick, they're not financially able to do it, maybe they don't live in the state of Ohio any longer, and it's too cumbersome to come back and forth. So we have to decide who is the proper person, the next best person to make that decision. I'm surely not going to appoint anybody that has a criminal background in regards to a sexual abuse, physical abuse on anybody, any type of abuse situation. I would be hesitant to appoint. We have to look into that because I have to make sure that the person that is being cared for, the ward, has the best care being provided to them and somebody making the decisions in their best interest and not somebody else's best interest. Okay, so we're going to talk a little bit about the responsibilities. If we go through the hearings and I find that a guardianship is necessary, now we have to determine, do we just need a guardian of the person or do we need the guardian of the estate as well? The guardian of the person is the person who handles the medical decisions, the personal day-to-day decisions. The guardian of the estate is the person that handles the finances. Most developmentally delayed individuals or individuals with disabilities, developmental disabilities, they don't have assets that you need to manage. They are typically Medicaid eligible. They have less than $2,000. And so therefore an estate is not necessary. because the only monies they get is from the state of Ohio, from the federal government, Department of Social Security. They get a monthly disability check from Social Security. That's a federal program that's administered through the federal government, through the Social Security Administration, and you do not need to account to those funds to the probate court. You account to those funds to the Social Security Administration once a year. So you don't need a guardianship to handle those funds that are coming in on a monthly basis under Social Security. However, we do have individuals that get inheritances, they have trust funds, they work, and they've accumulated money over the years, and that a guardianship of the estate is necessary because maybe they own their own home, maybe they have automobiles, maybe they have investment accounts, and you need somebody to handle those finances in addition to their Social Security check. So that's where we would talk about the guardianship of the estate and if a guardianship of the estate is necessary. I'm going to talk a little bit about what's the responsibility of the person, guardian of the person, and guardian of the estate. If you just need to make medical decisions, living decisions, day-to-day decisions for your ward, then we would just appoint a guardian of the person only. You would handle the Social Security check through the Social Security Administration, and you would just ask the probate court to appoint you guardian of the person only. That would allow you to make all types of decisions on a daily basis that deal with life, school, work, those types of issues. That's the guardianship of the person. Once a year, the guardian of the person has to file a guardian's report with me. Those reports tell me on a yearly basis where the guardian's now living, how they're doing, when's the last time they saw a doctor, when was the last time you saw them, how many times do you see them, what's the frequency of your visits, have you noticed any changes in your wards over the last year. That just keeps me informed on how they're doing. The second thing you have to file with that is called an annual guardian's plan. The guardian's plan tells me what you expect to do for that ward in the coming year. Are you going to get them enrolled in a residential program? Are you going to get them enrolled in some sort of an occupational program? It tells me that you're working toward helping them grow and live a useful life that is good for them and fulfilling for them. I don't want somebody that's just going to become guardian of the person and not make any decisions and not do anything for them. I want somebody that's going to be an advocate for them, that's going to foster their wants and their desires, but also be there to guide them if they need help making certain decisions, but then also be able to make the tough decisions if they can't make it themselves. Your job is to protect and control the ward as guardian of the person. So you need to be responsible and you need to seek services for them. You have to help them reach the highest degree of functionality in the least restrictive environment possible. We don't want them just being placed in some sort of a institutional facility if that's not in their best interest. Now, we have some individuals that's the only place that they can live. That is appropriate for them. But there's a lot of individuals that can live in some sort of a group setting or maybe even individually in their own apartment with some assistance. And the DD board and your SSA at the Developmental Disability Board will be able to help you make those decisions and tell you what services are out there. I don't want somebody somewhere where they don't want to be and where they're not qualified to be. We want them in the least restrictive setting possible. Okay, so you have to keep that in mind. You're going to make all decisions in the best interest of the ward, not yourself. You have to make it in the best interest of your ward. What would your ward want in this situation? Not what you would want. You want to keep the court informed of the ward's address all the time. Before you move the ward somewhere, you want to let the court know before you do it. You simply send a letter to me, say, I want to move my ward to this address, and here's the reason why. Most of the time, they're very valid reasons. I want to move them because This is a better apartment. It's bigger. It's cleaner. He has more friends local or close by. I want to know why you're moving them. Every once in a while, we'll get a guardian that wants to move the ward somewhere where the ward doesn't want to go. They don't want to live on that side of town, or they don't want to live over there for a reason. And then I have to make the decision whether that's in their best interest or not, because the ward's saying one thing, the guardian's saying another. That's what the court's decision is to make those decisions. And I take all the evidence and then I make the decision. The last thing you want to keep in mind is that you want to make all decisions in the best interest of the ward, not yourself. You don't want to impart your beliefs or wishes upon the ward. The ward has a right to participate and express their wishes. So that's really important to keep in mind. Now, if you do say, well, you know, Judge, my ward does have a pretty significant estate. They have other monies other than Social Security, and we need to be able to handle that. Well, then you're going to need the guardianship of the estate. The guardianship of the estate, it's your responsibility to take those assets that belong to the ward. You need to protect them. You need to account for them on an annual basis. And then you have to ask me permission to do something with that. If you want to spend money, if you want to invest money, if you want to gift money, you have to ask the court for permission before you do it. That's if you have guardian of the estate. If you're just handling Social Security money, once again, you don't need guardian of the estate. You can spend that money how you believe is in that person's best interest, because Social Security has determined that you are the appropriate person to make that decision. What I'm talking about here is guardian of the estate. If the person has got an inheritance, if they have their own money that they've
This is our first one.
job through maybe the lottery. We have a lot of people that hit minis. If they have funds that belong to them, you can't just take it and do what you please with it. You have to get the court's permission.
Why?
On their behalf.
I don't think they can hear me.
The first thing that you have to do as guardian of the estate is you have to file an inventory with the court. And you have to do that within 3 months of being appointed as guardian. I want to know where their assets are at and what do they consist of. Is it money in the bank? Is it a house? Is it an investment account? Is it stocks, bonds, CDs, IRAs, life insurance? I want to know what it is. So you have to file that inventory. The next thing that you have to do is, if you want to start using some of those assets to take care of the individual, you have to obtain prior court approval. You have to come down to the court and ask me to do that. Tell me why you want to spend it a certain way. I'm pretty liberal with spending money on the ward's behalf, but I want to make sure it's being spent on the ward's behalf and not somebody else's behalf. Frequently, I authorize money to be taken out of their accounts to go on trips. The family's going to Disney on a trip, and they want to be able to join the family on a Disney trip. So the family needs the money for their portion for airline tickets or for their portion of the hotel room. I will authorize that. Typically things like automobiles. If the person is capable of driving, you may want to buy an automobile. Well, I have to look and make sure the person can drive. Do they have a driver's license? Are they capable of driving safely? Can we afford the insurance? Where are they going to be driving? We look into all that, all those types of decisions. We have a question here in the audience. Yes, sir. Yes. Question here, so everybody can hear it, is there a trigger point where if you want to expend funds, if it's a certain dollar amount or above, you have to get court approval? And the answer is no, there is no trigger point. If it's $1, you have to get court approval. I don't know if so much was, it was a little bit of a question, it was somewhat of a statement. So the question was, to this gentleman, it seems a little bit onerous to get a guardianship of the estate, and it is. That's why I said most of these individuals don't have an estate that you have to worry about that. This would be money that comes to them that from an inheritance that somebody didn't do the proper planning. If you did proper planning for your loved one and you passed away and you wanted money to go to your child, you would leave that to them maybe in a trust fund or a stable account, and then you don't need to get court approval on that. This is just money that comes to the guard or to the ward, maybe unexpectedly, or it was accumulated during their minority age, working or through gifts, or maybe through a lottery winning that you didn't expect them to win, and it just happened to come upon them. Then the court has to get involved. And then what typically we see with it is that if you need monies frequently, the guardians will ask for a monthly budget. Please allow me to budget this amount of money and spend this amount of money for these items. And I will review that. And if it's appropriate, I will let you do that every month so you don't have to come back month after month. I will just let you do that annually. And then you account for that at the end of the year. Okay, good question so far. The last thing that you have to do is, like I said, once every year on the anniversary of your appointment date, you have to provide an annual guardians account. The guardians account tells me what happened the year before, all the money you spent out. So everything that you brought in on behalf of the ward and everything that you spent out on behalf of the ward, and that better match the applications for the approval that you sought ahead of time. So you want to make sure that you get prior court approval, and then you spend it according to those approval requests that I give you, and then you account for that every year annually. So you say you started with $10,000, you spent $2,000, and now you have $8,000 to start the next year. And then the following year, you'll start $8,000, you spent $2,000, now you have $6,000 left. So that's how that accounting works. Okay, so now we get to the part about what if you have a complaint about a guardian? What happens? What can you do? Well, the complaint process is a formal process at the probate court. It's known as Local Rule 66. Anybody, and I mean anybody, that has dealings with the ward and the guardian, if they have a complaint that the guardian's not acting in their best interest, is not doing something quite right, is maybe abusing them verbally, physically, emotionally, they can, anybody can file a complaint with the court. I tell all my guardians, you have to make your decisions on the best interest of the ward. That's the most important thing that you have to keep in mind. You're making decisions for your loved one. And in this case, it's probably your child. When they were younger, you always made decisions based upon what was good for them. You can't import your views or your wishes, because as your child ages, they're going to have maybe different views than you do. And you need to respect that. So you want to be able to make those decisions. And sometimes it's hard. Sometimes you don't want your child to be able to go live independently because you want them to stay at home with you. But they really want to go out and live on their own, or maybe in a group setting. And it's hard. I always tell people, it's hard to let your babies go. They're your babies no matter how old they are. My babies are still my babies, and they're in their 20s now. But it's hard to let them go, but you have to. And so if that's in their best interest and you have everything set up properly that they could live independently, you have to make the decision to let them go and live on their own. If there's a problem, then we come back and we reassess. There's nothing saying you can't let them go and then maybe come back and reassess and say maybe it didn't work out. You want to give them that opportunity. If they fail, that's okay. That's part of life. Failure is part of life. We learn from it. We're going to make some changes, and maybe we do something a little differently. Maybe they're just not quite ready at that stage of their life. Maybe they just need to wait a little bit longer, and we'll try it again. So you just never want to make one decision and it stays that way forever, because things are changing. Your child's changing. The guardian complaint process, what do you do if you have that problem? Well, it's simple. You just simply write a letter to the probate court and say, I have a problem with a guardian. I don't like what they're doing, and here's what I don't like. This is what I've seen. This is what I've experienced. This is what I have a problem with. I want you, court, to look into it. If that happens and I get that complaint, I then urge the complainant to first talk to the guardian. Have you talked to the guardian and just simply said, hey, I have a problem with how you're doing this? Because a lot of times it's just miscommunication or no communication. So try to talk to the person. Try to talk to that guardian and say, this is what I don't like. Maybe they'll change their ways. If not, then you can file the complaint with the probate court. And that's under local rule 66.03B. Anybody can file that written complaint. Once I receive the complaint, and I believe there's some validity to it, I will send a copy of the complaint to the guardian, and I will request them to file their written response to that complaint within 15 days. So they have 15 days to send me their written response. After I get their response, I can do a couple things. I can just dismiss the case. I can say, you know what, there's no valid point to this. I can dismiss it. I can order it to a mediation. I can have a mediator come in and mediate it. I can set it for a status conference and bring all the parties down and say, what the heck's going on? I can appoint a guardian ad litem to go out and
come over here and do this.
where the last thing I can do is I can have the hearing myself. The matter gets referred to me.
I know.
And I can do a bunch of different things. I can remove the guardian. I can appoint a different guardian. I can order people to go into respite care. So what I typically do is I mostly set it for a status conference, and I bring the people down and I ask them, what's going on? Can we resolve this in an amicable way? If not, then I have to make the final decision what happened. Sometimes people like my decision, sometimes they don't. But I'm going to make it, I can assure you, I'm going to make it in the best interest, what I believe is your loved one. And that's what I want. I want them to be engaged. I want them to be fulfilled. And I want them to have as least restrictive environment as possible. So that is guardianships and power of attorneys in a nutshell. I will open it up to questions. If you have some questions, I know you can type it in and we'll get them here. I have some people in the audience here. It has some questions. So I'm going to first open up to the audience here and give the people a chance to type. Sir?
A few. I'm assuming when appointing guardians, the guardians, the lead guardians, can submit sort of a matrix of similar to probate court we were doing in the state. So guardian A, B, and B aren't available in the drop down C, and this is already approved in the document.
Yes. Okay, so I want to repeat that for the people online. So it's a little different doing these online now, so we have to make sure we repeat it. The gentleman asked, is it possible that if you want to nominate a guardian for your loved one, your child in this case, you have the ability under your last will and testaments, you also have the power under your own power of attorneys to nominate guardians for your disabled children. You can do that for your minor children, but you can also do it for your disabled adult children as well. You can say, I want my oldest child to be guardian of my disabled child. If they can't be guardian, I want you to look to my brother. If my brother can't do it, then I want you to look to my sister. If my sister can't do it, I want you to look to, you know, this person, a close family friend. Yes, you can nominate them in your documents. Those are your estate planning documents. And I encourage you to do that, because if you do that, that gives me some guidance, because you have to remember, I don't know your loved one. All I'm going to know about your loved one is what's given to me in the pleadings, by the statement of expert evaluations, and what my investigator does in their investigation. So I don't know your child that well. So if you can tell me, hey, this person is the first person I want you to consider, then I'm going to do that. I'm going to make sure that they get a criminal background check, that I run them through some databases that I have to make sure they don't have any abuse charges against them. And if they meet the criteria, chances are I'm going to appoint them because you thought so highly of them to put them in your documents. I'm going to highly take that under consideration. So good question. Next question. Good question. The term of the probate judge is 6 years. You were close. It's not 4, it's 6 years. And we have to run for office every 6. I will be up in November of 2020 of this year. So I'll be running for probate judge again.
Does the staff continue on with the next if there is a change? I just think about this will be a long-term issue for us.
Sure.
And we make multiple
probate judges. Well, hopefully you will not be dealing with multiple probate judges, and I will be there a long time. But you are correct. If I would lose election, most often the probate judge keeps some of the staff, not all the staff, because the judge has the priority to bring his own people in. But I will tell you, the last 3 probate judges have kept pretty much most of the same people. There have been a few here and there, but most of the people are still the same, and they've been there a very long time. My court administrator's been there 32 years. My chief deputy clerk has been there close to 20. So there is some continuity. But that's why those the statement of expert evaluations and those guardian reports and guardian plans are so important, because those get put in the file, and we review those annually. When they come in, we're looking at those, and we look back at the old ones to see what has changed in that person's life. So yeah, so there is some continuity with the changeover in the judge. That's okay. The question was, how many people are under guardianship currently at Mahoning County? And currently it's just shy of 1,400 people. It's pretty substantial. I know in Cuyahoga County, they have over 5,000 people because bigger county. Our county is a medium-sized county, a large to medium-sized county. I take that responsibility, that role very, I hold it very in high regards, because these are people's loved ones we're talking about. And we're not just talking about children here. We're talking about individuals that are 70, 80, 90 years old in nursing homes, assisted living facilities. Some are still living at home. I have a lot of individuals with DD, I consider them part of my family. I'm going to make the decision based upon their best interest, because I know you care so much about it. And the probate judges around the county, or around the state, are the same way.
Let's say guardianships devastate the community, and there isn't any guardianship for the work is that fault?
Well, yes and no. The question is, if a guardian becomes incompetent, did I understand that correctly? If a guardian becomes incompetent, does the probate judge then have to manage that guardian's estate? And the answer is yes. We would appoint a guardian for the guardian. We would remove the guardian of the child for the child, and we appoint a successor guardian in that. Are my appointments typically attorneys? And the answer is no. Some are. Most are family members. We always like to try to get family members if they qualify. That's the priority, because they have the most contact. They know you. They know your family situation. They know your heritage. They know what your wishes are more likely than a non-relative. If we don't do that, then we have a couple service agencies in Mahoning County. We have Compass Family Service, and Help Network has a guardianship program. We used to have Catholic Charities, but they did away with their guardianship program recently. So we have those two public agencies. There is also advocacy and protective services in the state of Ohio that is authorized under the Ohio Revised Code, that they can act as representative guardians for an individual with developmental disability. They have a pretty substantial number in the state of Ohio. I think in my court, I think they have about 50 individuals that they manage right now. And they have social workers that make the decisions for those individuals that don't have any family, or we don't have a service agency that can provide for them. But if I don't have any of those, then I usually look to a lawyer, local lawyer to help. I used to do that when I was in private practice. I was guardian for some individuals. It's a big responsibility because you're going and checking on them. You're making medical decisions. You're helping them in some of the darkest times of their lives. But you're also helping them at some of the most joyous times of their lives. When somebody gets married or somebody graduates, you're there along with them. I've been to funerals with family members that I've been guardians of, and it's like losing a loved one because you become attached. You get to know them real well. I think we had a question in the back there. Megan. Okay, good. So the first one is from a single dad. I don't have the money for the lawyer for the process of guardianship of my son. What can I do? Okay, so the question was, if I don't have a money to pay an attorney to start the guardianship process, what can I do? I have I said early on, you may have missed it, I have a list of attorneys down at my court that you can come and you can ask. They volunteer their time to help people get through this process. And so they will not charge you to do this process. So we'll appoint them on your behalf. They'll set an appointment with you, you meet with them, and they'll help you through that process at no cost to you. Good question. Yes, great question. Do I have the application that you can fill out? And is it in Spanish? And the answer is yes and yes. If you go to my court's website, the Mahoning County Probate Court, just run a search, Mahoning County Probate Court. I think it's mahoningcountyprobate.oh.gov. I think, I'm not sure, they keep changing the tag on me. But run a search for the Mahoning County Probate Court. Under court forms, you will find the application for appointment of guardian. You'll see the statement of expert evaluation. You'll see all the standard probate forms, and you feel free to print those out. If you have an attorney handling that for you, they will help you do that. If you need a translator, we have translators available that can help you, but most of those forms are in Spanish, so you can get those translated so you understand what you're filling out. But we can also get you a translator through the Supreme Court at no cost to you that can help you fill out those forms. And during the hearing, if you don't speak English or your ward doesn't speak English, we can have a translator available. Good question. Any more? Oh, okay.
One, can your guardian live out of state?
Okay, then the question is, can a guardian live out of state? And the answer is, if they are guardian of the person and they are related by blood, they can live out of state. If they are not related by blood and they do not live in the state of Ohio, they cannot be guardians. So they have to be related by blood and they have to live, they can live outside the state, but it's guardian of the person only. Guardian of the estate, if you're handling their money, you have to live in the state of Ohio. The reason being is that if you do something wrong with that money, I want to be able to reach out and grab you and bring you into my court and say, what happened to the money? So the statute does not allow people to be appointed outside the state for guardianship of the estate. Good question.
Can you have co-guardians?
Question is, can you have co-guardians? This is always a question I get, and this is a tough question to answer. The answer is yes. I do not like co-guardians. I know parents want to be co-guardians, and I will acquiesce to that a lot of times. However, it sometimes becomes problematic because you have to realize down the road when you get into a situation where a really substantial decision needs to be made. A lot of places, when they see co-guardians, they're going to require both people be there making decisions and signing the paperwork. So it becomes problematic and becomes cumbersome. I like to have one person. So I try to talk to the mom and dad and say, is there one person that takes them to the doctor more often than not, or is with them more often? Let's appoint that person. If something happens to that person, then I'll appoint the survivor of them, the successor. So I will acquiesce to parents being co-guardians, but I will not do it for brothers and sisters or aunts and uncles. I only want one person, because when you need a decision made, you need one person to be able to make it. And I don't want co-guardians fighting. I need one person to make the decision.
And I have one more question. To become a guardian, I know previously there was some discussion about classes or something they would have to take. Do they still need anything like that to become guardian besides the evaluation and the application? Yeah, good question. If you want to become a guardian, do you have to do any training? And it's a compound question, and I have a compound answer to it. The answer is yes, typically you have to do a guardianship training. It's a 6-hour training class that's offered through the Ohio Supreme Court. You can do it from the comfort of your home, like you're doing right here with the Zoom. You just go on the Supreme Court's website and you follow this program and you'll get a certificate. But I have an exception for parents with children of disabilities. I do not make you go through the class. I encourage you to do it because it's going to give you some useful information on how to help that individual as they age and how they mature. And there's a lot of things on public benefits, on end-of-life decisions, on decisions for medical. There's a lot of good stuff on there. So I'm going to encourage you to do it. But because you've been taking care of this child for the first 18 years of your life, I don't think you need help on how to take care of them. So I don't make you do that. I waive that requirement. But I'm going to encourage you to do it. If you have your son or daughter that wants to be the guardian, they're going to have to take the guardianship class. And that's a requirement before I'm going to appoint them. So I usually tell them to start it ahead of time. They technically have 6 months to complete it. But if you start it ahead of time, it's pretty simple. You sit here and watch basically a Zoom meeting. You watch like you're doing now, and you get to learn about the process. There's a whole list of subject matter that you can talk to. The first class is 6 hours, and then they offer 3-hour increments after that that you can listen at your leisure. There's a lot of good stuff on there. So just go to the Ohio Supreme Court, Continuing Education, and you'll look under Guardianship Training. It's also, I have the link on my court website. If you go under Guardianship Training, there's a link that will take you to the Supreme Court site. You have to sign up for an account on the Supreme Court's website, but that's just making a name and a password, and then you're in. And then once you're in, you can see all the different classes. You can click on it, and it'll automatically start playing for you. Great questions. Any other questions? All right. Well, good. Well, thank you so much. I love talking about this. This is my passion. Before I was the probate judge, I practiced probate for 23 years, and I did a lot of guardianships, a lot of power of attorneys, and I had a lot of individuals with disabilities, and that was a joy of my practice. So I wish you well, stay safe, and just make sure you take care of your loved one. And if you have any questions, feel free to call the court. Thank you, guys.
Emily?
You're welcome.
Emily?
We did have a couple questions about the recording of tonight's session. So if you were wanting to go back and watch parts that maybe you missed, or there was something that you weren't quite sure about, it will be posted on the Mahoning County Board of DD website. We'll likely put on our Facebook page when that's up. We're also going to try to get the links to the probate site where you can find all the forms. We had some forms here tonight that we'll try to scan in as well so that you can have access to copies of those. So we want to thank everybody for participating, for being here. Lots of great information that we had, and we'll look forward to the next time we get together.
Feel free.